Good afternoon, everyone. At the outset, let me congratulate to all fellow members on the occasion of 55th Foundation Day of ICSI that we have celebrated with such great fervor in the august presence of Honorable President of India, Srimati Draupadi Murmu, uh, and Honorable Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman. You all would agree with me on the occasion we have just celebrated. This is memorable not for institute, it is memorable to every individual who are associated with our this premier institution. The expectation enlisted by them will be chalking out way forward, but it cannot be forgotten that true professionalism lies in constant self improvement and development. And it is with this thought and foresightedness that the ICSI had launched the Master Knowledge Series, EEE, for the company secretary to brush up their existing knowledge and took them privy to the recent amendment and changes having taken place in the regulatory and legislative arena. Till date, 10 webinars covering different provisions of Companies Act and SEBI law have been conducted under this series. I feel honored to host the next one in line that take this opportunity to welcome each one of you at the 11th webinar of Master Knowledge webinar series Evaluate Excel. Today webinar series is themed at yet another critical topic: inspection, inquiry, and investigation under Companies Act 2013. It's only efficient and smooth functioning of the corporate that can ensure an adequate return on capital invested by a stakeholder. Thus, with the introduction of Chapter 14 of the Companies Act 2013, companies are now forced to introspect and leave no stone unturned. This chapter deals with the provision related to inspection, inquiry, investigation of the affairs of the company, and thus very much critical towards building an environment of good corporate governance. Yesterday, in August presence of Honorable President and Honorable Finance Minister, both focus is on about the corporate governance. That governance leads to sustainability. So, sustainability can be achieved by doing good corporate governance by following the good practices. So, it is up to the corporate how, and more so, the company secretary is the person who can do this in practical terms. So it is we as a company secretary are responsible for this job, and wherever we are trying our best to convert this concept into practicality. To guide our way, we have among us Sri Manmohan Juneja ji, retired in the rank of Additional Secretary, Director General of Corporate Affairs, Government of India, Ministry of Corporate Affairs, to lead the way. We welcome you, sir. And I know, sir, since last 25 years, and he is one of the person who is always towards the profession, always towards the corporates, and always to assist the corporates in whatever manner whosoever be approaching him. Holding a vast experience of 35 years, conducting inquiry, inspection, and investigation of corporate irregularities and corporate frauds under Companies Act, LLP Act. He is presently appointed as the Center Council member, government nominee in the Council of Institute of Cost of Works Accountant of India since 2019. A fellow member of ICI, his experience ranges from appearing before NCLT and CLT to representing ministry at various national and international forums. A regular speaker in many seminars, study circle, and training, etc., for professionals and officers throughout his career. He is revered amongst professional fraternities for his clarity of thought and opinions. Sir, it is indeed an honor to have you amongst us, and we welcome you to this webinar. Sir, now it is up to you, and our members is really going to enjoy this session. So please, sir, it is up to you.
Thank you, Manoj. I'm really thankful to you and to the Institute to give me an opportunity to speak on this subject, which is very interesting subject. And for a practitioner, of course, this is a vital subject also. Dealing with inquiries, inspections, and investigations under the Companies Act, what constitutes it. And I have already shared the presentation. Probably one can share, someone, a technical team can share that presentation. Yeah. So, as far as the structure of presentation is concerned, first we'll deal with the legal provisions which cover inquiries, inspections, and investigations. Shortly, we can call them as 3 I's. Then we'll, and it will be interesting for any person, any practitioner to know from the practical side of the subject as to what triggers the 3 I's. There are, 18 lakh companies. Of course, the government cannot go after every company to conduct inquiries, inspections, or investigations. And at what level an inquiry is conducted, or why a decision is taken to conduct an inspection or investigation, what are the parameters, how the authorities choose, at what level, these three things are, and why these three different things are there in the act. So those we'll be discussing those, triggers. We'll also discuss what type of non-compliances or irregularities are detected or expected when any IO or the registrar conducts inquiry or inspection or investigation. What is the nature? How do we detect it? And then, of course, the most interesting part into these 3 I's is fraud and punishment for fraud. We'll touch upon those subjects also. And why and how these frauds are committed, what are the temptations, what are the allurements, who commits it. We'll be conducting some part, if time permits. We'll go through that nature, and what are the expected logical conclusions expected from the both sides, from the point of view of the regulator, the enforcer, the registrar, or the MCA. Having what conclusions do they want to draw, what are the deliverable points into these 3 I's, and what is the expectation of a complainant or a person who or a victim or a beneficiary or of the corporates also. We'll discuss those logical conclusions also. Ultimately, whenever a 3I is conducted, some logical conclusions are expected. Otherwise, if we don't draw any conclusions out of it, or if we don't have any takeaways out of it, this will be a futile exercise. Next. Chapter 14 is the concerned chapter, which deals with inquiries, inspections, or investigations. It spreads over section 206 to 229. Since we are talking of frauds or fraudulent activities, we'll discuss a little bit about section 447, 448, and 449. Other relevant sections which I have included in my presentation are section 130, 140 subsection 5, 132, 241, 242, 246 read with 339, 224 subsection 5, and also the provisions of the Companies Act, particularly 447, which is included as a scheduled offense under PMLA. Next, please. So section 206 basically starts with an inquiry, which is a very preliminary inquiry, which is the power of the registrar to conduct any inquiry. So the law says opinion of the registrar. So there are many case laws, and there are what is expected from the registrar, and how a practitioner can deal with it is that the registrar has to form an opinion. So when we talk of forming an opinion, That is a mandatory sort of requirement for the registrar to initiate an inquiry. So opinion cannot be formed just out of thin air. It has to be based on some material facts. So the law says that when a registrar forms an opinion on scrutiny of any document filed by the company, we know that the registrar maintains the electronic registry, the repository of the documents filed by the companies throughout the life cycle. Most of the people think that it is only the scrutiny of the balance sheet or a financial statement which triggers an inquiry. Normally, yes, because financial statements or annual reports or annual returns are the sum total of the activity of the company in a particular financial year. But the law is open that the registrar can form an opinion on scrutiny of any document filed by the company throughout its life cycle, right from the beginning incorporation of a company to its formal death or winding up of a company, or any information received by him. Now, information can be anything. Information can be a complaint. Information can be any reference sent by the outside authorities. Or information can be even, a media report. But the moot issue is that the registrar has to form an opinion. And when he forms an opinion, he has to issue a written notice. So before issuing a written notice, practically, we are living in the time of right to information. So it is the duty cast upon the registrar by the law that he has to form an opinion, means he has to write down in the note sheets what are the basis for him to form an opinion, what is the justification behind the information which is available to him, what scrutiny he has made, what are the gaps in those documents which are sufficient for him to form an opinion. That further information or explanation is required from the company. This is very simple and very preliminary. It is not a show cause notice. It is not a threat to file any prosecution. It is only limited to forming an opinion that yes, something is amiss and further information or explanation is required from the company. Then the next step for him is to issue a written notice. It cannot be oral. He cannot pick up the phone and tell the company, okay, you give me that information. It has to be in writing to furnish such information and explanation or to produce a relevant document. Then, of course, he has to specify the time within which it has to be given. So these are very basic requirements for the registrar to initiate any inquiry. Now, what is the duty of the company? Of course, duty of the company is to comply with those directions. Now, the difference between the old 1956 Act, now it is already, all of you must be aware, 10 years now, 2013 Act is there. So even past employees are also duty bound if so called by the registrar in a notice in writing. So past employees or past managing directors or past directors or even past company secretaries.
If we are saying about past, so past related to that particular matter on which basis registrar has formed the opinion or anything.
No, it cannot be, as I said in the very beginning, it cannot be out of thin air. It has to be justified. When he forms an opinion, it has to be on the subject only. It cannot be vague. It cannot be, when he issues a notice in writing, it is, of course, his duty to say why, if certain information is required from a past employee or a past director, something has happened or something matter which is complained of, right? Or a subject matter. So it happened during his period. Probably he is having, he feels that he has that information and he can help, he can provide that information, then only. It cannot be vague or just out of his choice that, okay, I will issue a notice to the past employee also.
Okay, sir. Thank you.
So now the next step is section 206 subsection 3, which comes into play. Now, if the registrar is of the opinion, when the information is not furnished at all, it can so happen that first notice goes unreplied. It is not replied at all. Or it is replied, but the registrar again is of the opinion that it is not sufficient, it is not complete, some incomplete information is given. Or out of that information given, some more information is required. Then again, of course, the same process has to be followed. He has to form an opinion. He has to note it down in the note sheet that what is missing, why I am of the opinion that further information is required, or further documents are required. He can call further documents to verify, right? So, or some extracts from the books of accounts or the secretarial records. So then again, he can issue a notice under section 20 subsection 3 specifying what additional information or explanation is required. This is basically a natural culmination. We are moving from a normal calling of inquiry, information and explanation, or here are the seeds, where an inquiry can actually culminate into a proper inspection of the books of accounts and records of the company. Next, please. Now, and the other part of section 20, subsection of section 206 is subsection 4, where there are, there is a very subtle difference between 201, 2, 3 and 206 subsection 4. In a normal calling of information, there is actually no hypothesis of any fraudulent or unlawful state of affairs. It can be a very simple sort of calling of information. If I have to give an example, if a complainant says that so-and-so minutes have not been maintained, or I was not called in so-and-so meeting, notice was not issued, or notice was not proper, registrar can simply call that information, right? Or a very, low-level sort of stray complaint is received, or there is no other, provision under the Act to call for further information, registrar can simply forward that complaint and call for comments of that complaint. So that is under section 206 subsection 1. But 206 subsection 4 deals with a bit serious issue, where on the basis of an information available with ROC, which mostly is a complaint or an examination of the documents, or a representation is made to the ROC by any person. So mostly any persons are persons who are stakeholders in the company. They can be employees, there can be a whistleblower sort of information. There can be an investor, or can be a secured or unsecured creditor. It can be a deposit holder. So that information that indicates, and there is a sufficient material to make a prima facie case that the business of the company is being carried on for a fraudulent or unlawful purpose, or not in compliance with the provisions of the Act, or grievance of the investors is not addressed. So ROC has a special separate duty, a higher level of duty, in comparison to section 206 subsection 1, that he has to inform the company of all allegations made against it by a written order, and may call for information or carry on an inquiry as he deems fit, but after giving an opportunity of being heard. There are very many cases, where high courts have held that these are the mandatory preconditions, mandatory duties cast upon the registrar by the lawmaker, by the statute, is that 3 things. 1, he has to inform the company of all allegations made against it. So you can't allege a fraudulent or unlawful activity just without or hiding anything from the company has to be informed that what are the allegations, and on the basis of those allegations, I am of the opinion that the business is being not conducted, or unlawful activities are happening, and then he has to give an opportunity of being heard to the company. So the notice has to be drafted by the ROC very carefully, that as to an opportunity is hereby given to you, that why an inquiry be not conducted, why so and so acts. So these are the certain preconditions. Normally, for a practitioner, job is to find holes into these preconditions and challenge the action of the ROC. I'm now on the.
Sir, now you are
So
on the
these
other
are
side.
no,
Sir, really.
no, no, no.
Sir,
I
really,
had
nowadays,
even on that side. I had taken. I was in a habit of taking care of all these
sir,
preconditions.
I remember I have one
And
case and
transparency in any case has to be maintained. And this is not something any rocket science. This is very logical also. That how a company can give you
more
how
so,
you
sir,
can be informed, how you can take an informed decision without actually, or how company can give you a meaningful reply unless the company is aware of the allegations. Company cannot give, neither the registrar is an astrologer nor the company, right?
absolutely.
So there has to be an informed letter and an informed, reply. And in
There
the
must be a substance. There must be a substance
and
in
in a
the
context,
complainant.
like if the allegation is with, just to quote an example, if the allegation is with regard to deposit raising illegally or non-payment of deposits, unless the company is aware of that particular allegation, company cannot, just assume that the allegation is with regard to deposit. It has to be, the reply has to be, with regard to deposits only, how the company is eligible to accept deposits, whether they have met the requirements of section 73, 74 onwards, what reserves have been created, how repayments are made. So this is in context. No reply or no exercise of conducting an inquiry can be out of context. So this is very logical, but okay, the law is very clear. The law, so unless law casts upon a duty, on one hand, people feel that it is the power of the registrar. I say no, it is not the power, it is the responsibility and accountability of the registrar. Okay, if you have been given an authority to call some information, that authority comes with responsibility also. You have to be reasonable. You cannot
And
be.
more so, sir, a green note is always there.
Yeah. You cannot be, I always say you cannot be trigger happy. आप ऐसा नहीं out of your just choice you pick up a company and throw a letter. No, it cannot be like this. There has to be a system, there has to be a justification and fairness. Ultimately, every law is I personally feel every law is basically all about justice and equity. Right. So that subject, that principle is very much clear from the provisions of the Act, particularly when we talk of a compliance law like Companies Act. So there has to be a little clarity on these issues. So that rightly so, the duty is cast upon the registrar and duty is cast upon the practitioner to find holes and then fight it out legally. So on one hand, the law has given this authority to the registrars, but the central government, in this case, central government means the Ministry of Corporate Affairs, can also direct the registrar or an inspector now to carry out inquiry under section 206 subsection 4. So it normally happens, practically it so happens that a complaint is directly received or a reference is directly received by the ministry. So then forming of an opinion part is at the level of the officers in the ministry. They form an opinion that, okay, we need to order an inquiry, there is a prima facie case made out that the business of the company is being conducted in a fraudulent or unlawful manner, then normally they order for the registrar to conduct an inquiry. But technically, the ministry can appoint any other person as an inspector. So if finally it is found that the business is being conducted in a fraudulent or unlawful manner, the natural consequence of it is punishment for fraud under 447, which will be dealing it in further slides. So finally, if it is known, or it is the finding of the report that the business of the company is being conducted in fraudulent manner, unlawful purpose, then of course every officer of the company who is in default shall be punishable for fraud under section 447. Next, please. Yeah. In the old Act, there were two separate sections for scrutiny or inquiry, 234 and 209A for the of the old Act for inspections, but now it is part of section 206 itself, subsection 5. So in addition to the powers of the registrar, the central government can also direct inspection of books and papers of the company. Central government by special or general order authorize any statutory. This is an issue of policy, but there are enabling provisions under the Act that the central government can authorize any other statutory authority to carry out inspection of the books of accounts. Like central government any point of time can take a decision, okay, for NBFCs, RBI will conduct an inspection, or say for listed companies, SEBI may conduct an inspection, so, or on case-to-case basis. So central government, it is the prerogative of the central government to pass such orders. Penal provisions are also there, of course. If there is a disobedience, to the orders of the registrar or inspector, company and every officer of the company can be fined up to 1 lakh rupees. Or if the default is continuing in nature, then additional fine which may extend to 500 rupees for every day after the first during which the default continues. So ultimately, it has to be honored. Every notice from registrar and inspector, of course, has to be honored and reply. Of course, you can seek time, that is another issue, but it has to be, it is my advice to all practitioners to respond to every letter or notice. Seeking time is not illegal. Seeking time is not disobedience, right? And I understand that the registrars and inspectors are also do understand the practical difficulties sometimes, and they can grant you additional time, but disobedience, of course, will result into penal action. Next, please. So how do we then? Section 207 is the relevant section. So it is, of course, the law casts duty upon every director, officer, or employee to produce all such documents and furnish such statements in such form as required and render assistance. The registrar is empowered, or inspector is empowered, to take copies and mark identification. The other power which is being used now as a matter of SOP, I can share with you that during my tenure we had compiled a manual of inspection and manual of inquiries also, where we had basically guided our officers that how they can go ahead or follow a process of inquiries and inspections. So in that process, we had guided them or advised them to use their powers which are there under section 207 subsection 3, where they have been granted powers of the civil court to call a person, issue a summon, directing the company for discovery or the officer to discovery and production of the books of accounts and records, summoning them and enforcing the attendance of persons. So this is, law is okay, but as a prudent inspector or a registrar, this is one why the law has given this power, is that this is interviewing is a very important part of conducting any fact-finding inquiry. just calling information, reading out the records, certain things will never come to light unless you record the statements of the relevant persons. For example, if I have to quote it, the attributes of shell companies will never come to light unless you interview the people. We have seen many cases where with the fact that a particular person or a director is a dummy director, somebody else is actually, calling the shots. He is, that person who's on records is just a director is actually a dummy director. And they have admitted in those statements only that yes, we are in the company just for a few bucks per month. We don't know what is happening in the company. We don't even go to the office. So and so person actually, conducts the affairs of the, and that person is nowhere in the record as director or an executive in the company. Such things do come to light only during interviewing or recording of statements. Similarly, non-maintenance of registered offices or certain financial transactions, so many things come to light only when you interview the people, when you confront them with documents in your possession or complaints in your possession. This is one part. That is an art of conducting a 3I or an investigation. The second part is that evidence, comes to light, and evidence is authenticated. When you exhibit certain documents to the person and he recognizes those documents, he recognizes the signatures, he recognizes the transactions which are disclosed, or disclosures made in the financial statements or in the documents, those evidences are placed as evidences when, when we file prosecutions. So then it cannot be denied. So two purposes are served when we interview a person. One, so many things come to light which otherwise remain hidden. And secondly, your evidence, becomes a proper evidence. So now, for last a few years, registrars and inspectors are actually recording statements of the relevant person, at least the KMPs, as per our manual. The other serious issue of, non-compliance of the summoning under penal provisions under Section 206, that every director or officer of the company is punishable with imprisonment which may extend to 1 year, and this is non-compoundable, and fine which shall not be less than 25,000 rupees, but may extend to 1 lakh rupees. So one, disobedience of Section 207 is non-countable. Two, on conviction. So there is a civil disqualification also. On conviction, the director or officer shall be deemed to have vacated his office. Usko directorship chhodni padegi. So this is the most serious, consequence of disobedience. If he is convicted and is disqualified from holding an office in any company. Strangely, unlike Section 164, which disqualifies a person for 5 years, no period is prescribed under this section. So logically or technically, he is disqualified for life if he is convicted for. So therefore, any notice under Section 207, subsection 3 has to be taken with utmost seriousness and responsibility. And, the person concerned should never take a risk of disobeying that notice. He should present himself before the IO or the registrar, get a statement recorded, say whatever he is in his knowledge, share whatever information he has in his personal knowledge, and identify documents. Something, of course, which is not known to him, that is a different issue.
Here, one question is there.
Yeah.
Whether at the time of inquiry, IO or whichever the officer is there, and we are presenting their accused person is there over there, it is necessary to give the answer of all the questions then and there. Can we say that we are not giving?
It is not necessary. Point is, there can be two things. One, recording of statement means something which is in your personal knowledge, right? One can even say ki, okay, I retired or I resigned from the company 5 years back, right? I do not remember, right? This thing. Or he can say, I had left the company. So whatever you are asking me is a subject matter of documents, right? So I cannot, I'm not in possession of those documents. Those documents can only be requisitioned from the company or the present company secretary or the present KMP, right? But if he's shown a document, it can happen that registrar says, okay, you say, okay, here is a document which is given to me by the company balance sheet. So which is signed by you. So do you recognize your signature? Okay. So then he has to reply, okay, yes or no, whether I had signed this balance sheet or not signed this balance sheet. Then the IO can even show him, say, notes to accounts, right? So, and since you have approved the balance sheet, since you were on the board of the company, do you remember anything, any background of, giving this particular, notes to accounts? So it all depends on facts of the case. But yes, plainly, it is not necessary. Nobody can force you, if you don't know anything, but you have to say something. I do not remember, or document is not in my possession, or if you show me a document, then probably I will be in a position to reply. Right. So like this.
Yeah.
So unlike the old act, so reporting is mandatory. Earlier under inquiry and inspection, the law, there was a gray area, there was a gap, so that there was no clear provision. Now under section 208, mandates upon the registrar and the inspector to submit a report to the central government. So report is mandatory. You can't just initiate an inspection or inquiry and then sit on it forever. So reporting, ultimately, it has to be brought to logical conclusions by submitting a report. So if practically I have to share with you how the channel moves, like if it is inquiry is or inspection is with the registrar, he submits his report to the regional director. Then under 458, there are certain delegation of powers. Now after decriminalization, powers are segregated. So if there are, technically it should happen that if there are violations which have come to light, which are punishable with penalty only, right? As per the decriminalized provisions of the Companies Act, the registrar should say that, okay, these provisions are punishable with penalty. I have separately initiated the penalty proceeding, right? Or he has to say that I have completed the penalty and I have imposed this much of penalty and this is the status of those proceedings. And if the offenses which are punishable, compoundable in nature, where the power lies with the regional director, no, the regional director, central government will not interfere into that. Regional director has to decide or give a sanction for filing those prosecution to the registrar. And for higher level, as per the delegations under 458, if the offense is punishable with 2 years or more, basically non-compoundable, mostly offenses, the power lies with the central government. So that part is left with the office of DG and the central government. So
it means, sir, at the ROC level, registrar level, it is possible in case of inquiry to levy the penalty and close the matter then and there.
Because the law has given the law has given, after decriminalization, 58 such offenses have been decriminalized. The power lies, nobody can interfere with the power of he is the adjudicating authority.
ROC.
So it will be in the fittest of the things where the registrar says that, okay, while conducting this inquiry, I have found 5 such offenses which are punishable with penalty. While submitting report, he can say, I have initiated the proceedings. Now these will be brought to logical conclusions, but here I am submitting my report that these 5 offenses were found. A report in total has to reach the central government by every duty which is given to different levels, ROC, RD and ROC. And thereafter, after conclusion of those penalty proceedings, he will submit another report. Okay, now, and that process of penalty proceeding is also well defined under 454 and rules thereunder, where registrar will conduct an inquiry or initiate issue show cause notice, and finally he passes an order. That order is also published on the website of the ministry. Appeal lies with regional director. Regional director order is also published on the website of the ministry. So that is a process well defined within the act. It will be sufficient on the part of the registrar to say that yes, I have initiated the penalty proceedings, and these will be brought to logical conclusions as per section 454 and rules thereunder. Similarly, when the regional director submits the report to the ministry, he can say, as far as, we call it part B. So as far as part B, violations reported in part B are concerned, I have given the sanction, or I'll be giving the sanction to the ROC on the merits of the case. So rest of the things can be seen by the central government. But logically, it can so happen practically, and I have seen in many cases where the central government has rejected certain reports in total, because central government is not satisfied at all with the quality of the report. Central government can give additional, or even RD can give additional, directions to the IO or the registrar. Okay, these parts are okay, but you have not seen this part, or you have not examined the core issue for which this inquiry was, conducted. The objective for which it was initiated, that objective has not been addressed. You have reported rest of so many other things, but that particular objective is not addressed. So it can happen. Then a supplementary is ordered. To that extent. Next, please. This is also a very important section, enabling provision under the chapter. This is used practically not in many cases, but only in a few cases of larger public interest involved, or where in normal course the company or its directors, they do not reply, or they do not cooperate, or when the registrar, the IO, is of the opinion that there is a possibility of destruction, mutilation, alteration of evidences, books, records, then they are empowered to, conduct search and seizure, but after approval from special court. I have not seen any case where special court denies that permission. If you make out a case, for example, practically, a notice is issued, no reply is received, right? Or frequently, again and again, time is sought, and the matter is such which is of public importance, right? And there are grave complaints of, say, diversion of funds or illegal raising of deposits, like chit fund companies and things like that. Then, after obtaining the approval of the special court, records relating to company, KMP, director, auditor, company secretary in practice, these people all are covered. But it is important for the practitioner to know this fact. So the IO or the registrar can go and seek search and seizure into any place or places where such books and papers are kept, are suspected to be kept, right? Power to keep such seized records up to 180 days and return, but empowered to call for further period of 180 days by an order in writing. And of course, he is empowered to keep copies before returning the record. And the provisions of CRPC shall apply to such search and seizure. To the best of my knowledge, this power is used in a few cases where there were serious issues, and there were possibilities on record and indications that the records can be mutilated or destroyed. Such search and seizure operations have taken place. Next, please. Then we graduate to another provision of Section 210, with the central government on forming an opinion may order an investigation. Now, investigation, if one has to say, so it happens like a preliminary inquiry is conducted by the ROC or by the inspector, and in his report, he feels that the scope and the subject matter and the time requirements, etc., and certain things which could not be covered under inquiry. So there is a need for an investigation. He has given some cogent reasons and recommends, basically, we call it as a recommendation of an investigation. Or on intimation of special, there is one or two such instances where I have seen that the company itself passes the resolution, special resolution, that it is a fit case to be investigated by the central government. Or there is a larger public interest involved, then central government shall order investigation. There are two parts. One is a discretion may in bullet point number 1, 2, and 3. But it is mandatory on the part of the central government to order an investigation when an order is passed by the court or by a tribunal. We have seen many cases where NCLT or court, where some proceedings are going on. So central government, the court or tribunal orders that investigation is to be conducted. Then the central government may appoint one or more inspector to investigate into the affairs of the company. Practically, investigation, once central government takes a decision that it is a fit case to investigate, practically the concerned regional director is authorized to conduct that investigation. Well, investigation is conducted in the office of the regional director, and the regional director is authorized to appoint an inspector. Central government asks him to appoint an inspector. So the regional director appoints any officer in his office or within his jurisdiction as an inspector to conduct that investigation. Next. Investigation by SFIU. Now we know that under the 2013 Act, SFIU has a
one point, sir.
Yeah. Yes.
In case of 210, resolution by shareholder, a special resolution by shareholder. So this thing, how government is taking for making a basis for investigation?
No. It all depends upon the material. I can, without naming a case, without naming a particular company, I can recall one such case where the company itself, came to know about certain financial irregularities and fraud committed by the ex-management of the company. Then the new management thought that it is a fit case where, we don't have investigative, skills or any authority, company itself, or if they appoint any other agency or private law firm or a chartered accountant firm, so that may not have that recognition before the eyes of the courts or tribunal. Then the company itself passed a special resolution that all this material which has come to our knowledge, all that initial evidences which have come to our knowledge, we should share it with the central government. And since the law empowers us to pass a special resolution, it was an unlisted company, of course. So the company passed a special resolution and requested the central government to order an investigation. An investigation, of course, it is another bit of information. Opinions are always formed on the basis of whatever prima facie case is made out and material is placed before the central government. I'll be coming to triggers. When we talk of triggers, I'll give you some more insights into that. But the fact remains that it all depends upon the material which is before the eyes of the And the law is very clear that at the opinion is not equal to finding, right? At the time of ordering an investigation, it is sufficient that a prima facie case is made out that yes, there is something which need to be investigated. There is a hypothesis which has to be negated or confirmed or affirmed, right? That is enough. I remember one such case by Coimbatore Spinning Mills case versus MS Srinivasan is a case which actually spells out very clearly what is the meaning of an opinion to be formed at the time of ordering an investigation, and this opinion can even get changed when a finding comes to light. Opinion is not equal to finding. That is why the law requires calling of information. No, my opinion can get changed, or when a fact is, every complaints have to be seen with some pinch of salt also. There can be motivated complaints also, right? Or can be a disgruntled employee who just raises hue and cry because something is found against it. It can happen. So that is why I say that all three eyes are all fact finding exercises, right? I have covered this aspect in my another slide.
Sure.
But certainly opinion is not equal to finding. Finding is based on hard evidence. So at the time of ordering an investigation and inquiry, it is enough if a prima facie case is there that it requires further examination. That's it. So SFI. So again, issues are same. The moot issue is main point is that it is the prerogative of the central government to order an investigation by SFIU. SFIU cannot pick up, as the law stands today, cannot pick up an investigation of its own, right? Central government has to pass an order, assign basically an investigation to SFIU. We have, ministry has, I was party to those. We have our own SOPs and systems which spell out which case is, fit to be given to, like you can see in these 4 bullet points, 3 bullet points are common.
Similar to
on receipt of report from registrar and inspector, intimation of special resolution in public interest. Then how do we differentiate between 210 and 212, right? On request from department of the central government, state government, then it will go to SFIU, right? So that is a 4th point which is added into this thing. Then how do we decide that it is a fit case under 210 or 212? So all I can say at this stage is that it depends upon the quantum of the alleged fraud, number of people alleged to be affected by that fraud, and thirdly, since SFIO is considered and established as a multidisciplinary investigating agency, so more than one law is attracted. The fraud, the magnitude or the complexness of the alleged fraud is such that it requires not only just the knowledge and expertise of Companies Act, it requires an expert knowledge and expertise on banking law or non-banking law, general banking, or SEBI laws or some other laws, CRPC and things like that. Many things are common, but it is all the nature of public interest, quantum of alleged fraud, and multidisciplinary expertise required. Like when, for example, if I say you are investigating a particular company, a standalone company, or are you investigating a web or a group of companies put together? Sure. And the magnitude is into multi-crores of rupees, 500 crore rupees, 1,000 crores of rupees. People affected are more than 1,000, 2,000, 5,000 people are affected, right? And a focused attention, is required. So then government may decide. There are in-house mechanisms how government decides. There are committees, there are people. There is a normal, decision-making process within the ministry. The issue moves from one officer, one level to another level. So finally a concerted decision is taken that okay, this case is fit to be given to SFIU, or it can be covered under just under 212. Next, please. So what is the difference? So the most important to know for any practitioner is to know what is the difference between an investigation under 210 and 212. Under 210, central government appoints an inspector, or the regional director is asked to appoint an inspector. When investigation is marked to SFIU, the director SFIU designates an inspector. Once an investigation is ordered by central government for SFIU, no other agency can investigate under this act. Recently, very recently, on 15th September 23, landmark judgment has been given by the Delhi High Court in the case titled Ashish Balla versus State and Another. Under 482 of the CRPC, the High Court has quashed an FIR saying that SFIU is already investigating the matter, and as per subsection 3, no other agency can investigate under this act. So therefore, the FIR is quashed, and Economic Offences Wing is also directed to hand over all those papers or evidences which he has collected to SFIU. Earlier, it was there only in the act, and we have been fighting practically. I can share it with you that we have been fighting with many agencies. Why you are investigating when the matter is purely of the Companies Act and SFIU is investigating. So there have been arguments and counter arguments. No, the objective of company is different. Here the objective is different. We are looking into IPC, you are looking into Companies Act. So a lot of correspondences and a lot of arguments, counter arguments were taking place. But now I feel we will definitely see if, of course, the order by High Court can be anyone can go to Supreme Court. We don't know what will happen in future. But if we look at this order, so this order now gives clarity and gives subsection 3 actually has passed the judicial scrutiny as of now. The other difference is that SFIU is vested with powers to arrest the accused. There were no this subsection was there in the act but was not notified. It got notified, I think, sometime in 2018 only. And now SFIU, there are many cases where SFIU has arrested certain accused. I personally know, and I have been dealing certain cases. ILF and FS is one such case, and there are many cases. Then there is another interesting case, of SFIU only, Rahul Modi's case, where Supreme Court has, somebody said that a person was arrested in this case. Somebody has gone to Supreme Court and challenged that there is a time slot given under subsection 3, which says that the report has to be given within a particular time. The time has expired and SFIU has arrested the person. So this arrest is illegal since SFIU cannot even proceed with the investigation. Supreme Court gave an order, no, this is only directory and not mandatory. So therefore, the arrest is justified and not illegal. Another very important part of section 212 is subsection 6, where there are twin conditions, to grant a bail. In all those offences, the law says that all offences under the Companies Act are non-cognizable except section 447. And subsection 6 of 212 puts two conditions. That no person accused of such offences shall be released on bail on his own bond unless PP is given an opportunity to oppose the application for such release, or where the PP opposes, the court is satisfied that there are reasonable grounds that he is not guilty and that he is not likely to commit any offense while on bail. So this makes, once a case is filed under 447 before the special court, and a fraud court takes the cognizance, so the bail is very difficult. It is almost impossible at that stage, to meet these twin conditions. So the important cases in this, I would recommend for every practitioner to go through the Supreme Court cases, in Nitin Johari's case and Neeraj Singhal case, and the above case of Rahul Modi and few other cases are there, which have recently taken place, where even Supreme Court and High Courts have recognized this, and dealt with these twin conditions. Particularly Nitin Johari's case, the bail was denied. Bail was given by the High Court, but the Supreme Court finally rejected on an SLP filed by SFI. Next, please.
Sir, the Supreme Court rejected in Neeraj Singhal case. What basis has taken for that? For that particular rejection.
No. One can argue on those, things for hours together. All what I am saying is that, for any accused, once 447 is alleged and a detailed report is there, just at the time of taking a cognizance, for any accused, which court will say that I am of the view that the person is not guilty? Which trial court will say that? Right? No court can say that. So this happened in all these cases, and the onus, sort of gets shifted on the accused. There are 15 such sections. Another food for thought, I give it to you. Mostly people feel that 212 subsection 6 is only in those cases where SFIO files a case, which to my mind is not true.
Absolutely, sir.
Because it is applicable to all cases, whether filed by ROC under 447. Because the law makes 447 as cognizable offense, right? So same grounds were taken in case of Nitin Johari and in Neeraj Singhal case also, right? He had also, in Neeraj Singhal case, finally he got bail, I think, if I am recalling it correctly.
Yes, sir. At the end of the things, he got the bail.
When the Supreme Court said that, there are a lot of accused in the case. In that case, there are about 300 accused. And the case will go on for years together. So there is no justification to keep the accused behind the bars for that, large number of years. So that was one of the grounds given that. So those are the lessons for the prosecutors also, that is it justified to keep that large number of accused, make them as accused in the complaint? Is it not sufficient if you keep KMPs and those persons who are actually, involved in fraudulent activities? What justification is there to keep even, low level employees as accused? Otherwise the case will never come to light and it will go on for years and years together. These are, just debatable and, points which are to be, to be considered for all concerned. Anyway, but it all depends in each case. It all depends on the facts of the case. There can be cases where large number of people are actually found involved in fraudulent activities. 213 we have probably already discussed a bit. The 213 is where investigations are ordered by the tribunal. Tribunal may pass order on applications by specified number of members or on allegation of fraudulent activities of the company or unlawful purposes or another matter specified under 1213B. It normally happens in those cases where there are the cases of oppression and mismanagement going on in courts, and certain parties do file applications that, look, it is a fit case for investigation. These are the, these are the justifications and evidences, and they request and pray to the court to order investigation. Then court orders, and if the tribunal orders that investigation, then the central government will pass an order appointing an inspector. Next, please. This is another enabling provision. Investigation into the ownership of companies. We had used this in case of potentially or alleged shell companies. Central government is empowered to appoint inspectors to investigate and report on matters relating to company and its membership, determine true persons who are or have been financially interested in the success or failure, real or apparent, who are or have been able to control to the material or to materially influence the policy of the company. Then the central government may, investigation may be ordered by the central government or can be ordered by the tribunal. Central government may define. So the other important aspect, in comparison to other provisions of the Act, is central government may define the scope of the investigation, define period or limit investigation to matters with particular shares or debentures. Let us take hypothetically take a case, a very simple case, just to understand the concept. Say two brothers are fighting, right? So they file some petition is going on before the NCLT, and there are confusions, or there are gray areas with regard to certain percentage of shares which have transmitted from one party to another party, or there was a will or something like that. So there is no clarity as to say who holds those 20% shares. There is clarity on 80%, but who is the real owner of those 20% shares? Central government can pass an order. Or let us take another, beneficial ownership. Earlier, under Section 90, when before the amendment of Section 90, when we brought the concept of register of significant beneficial ownership, there was a provision under Section 90 itself to investigate into the beneficial ownership of the companies. So that is now changed. So that Section 90 is now limited to reporting the significant beneficial ownership. And Section 216 can be used to investigate into, there was a little bit of duplication. So 216 can be used to find out those facts and things like that. Or in case of shell companies, where certain people are hiding behind the corporate facade, and there is a prima facie case or evidence available to the central government or is brought before the tribunal that so and so set of people or person are actually having the controlling, or they are actually financially interested into the company. So investigation can be ordered. Section 220 is also an enabling provision where imposition of restrictions can be there upon securities. Just as, for example, I said that 20% of shares, we don't know who hold. So if those shares are allowed to be transmitted or, transferred freely, then the whole purpose of investigation will be defeated. So restrictions can be put on, for a period not exceeding 3 years on transferability of those, securities. Next, please. Okay. So these are other provisions.
Sir, one question related to this beneficial ownership. Recently, MCA side, lot of notices, ad hoc notices issued to every every company, almost every company. So in that case, with lot of mistakes in that notice. So companies had given that reply to the particular that notices. So can MCA is going to take further action on that or what? Because everyone has given the reply of those
And look,
notices.
let me. Well, I am. I today I have no authority to say what MCA will do in that case. Right? But I can only discuss on the legal aspects of it.
Yes, sir. That's I want to know. And our members also want to
Definitely that notice is not an investigation under 216, right?
know. Sir.
That notice, what I can understand is that those notices were generated. I have another slide on triggers. Where how we get that information. Anyway, since you have asked that question, there are terabytes and terabytes of data within the MCA21 system.
Sir.
Even when I was there, we had, or probably there after that also, we had identified certain triggers where system can throw some alerts, or system can throw mismatches, right? And on the basis of that systematic, information or list generated from the system, the in notices or letters can be issued to the concerned companies or persons to call for further information only. So those notices were in that direction, to the best of my understanding, were calling for information.
So
Now,
it cannot be treated as Section 216 notice.
otherwise, what section do ROC has, to call for information? Or कोई section है क्या law में? कोई है ही नहीं.
I
है नहीं. If the registrar, the central government has to call for further information, there is no other provision except 2061. There is no other provision.
no
Right?
other problem.
चाहे उसमें लिखा है कि नहीं लिखा है, but
Hardly no.
ultimately it means that they are only calling for information that as per the data maintained by data repository, corporate registry, this mismatch has come. Now you give us a reply. Now something which is, if there is a mistake apparent on record, right? As you are saying that there were certain notices were wrong, factually incorrect, right?
Sure.
So to the best of my understanding, something which is factually incorrect and mistake is apparent on record, definitely no further action comes out of can come out of that. Definitely. But if there is a violation, then of course that has to be brought to logical conclusions in each and every case.
Sure.
Okay. So procedures and powers of the inspectors are defined under 217. Employees are given protection under 218, that they cannot be removed during the course of investigation. Inspector is empowered to conduct. So this happens in many cases when we order an investigation under 210 or 212. Mostly in 212 it happens. SFIO, seeks, power of the ministry or permission of the ministry to include certain more companies within the scope of investigation under 219. That the investigation cannot be brought to logical conclusions unless so and so more companies are included within the ambit of investigation. Inspectors are empowered for seizure of documents during investigation. That goes without saying. Freezing of assets of the company and inquiry investigation by tribunal. There is a specific order. In this case, it is in public domain. That is why I'm saying I had got that order. In case of Nirav Modi and Gitanjali James case, where NCLT Mumbai had passed an order under 221 that the assets of the company will not be free. There is a freezing, will not be frittered away during the course of investigation. The purpose behind it is that on one hand, investigation is going on, and in all probability, there can be disgorgement and assets have to be protected basically. If on one hand, and it is on the premise of fraud. So a tribunal can pass an order under 221 or on a complaint under 244, and then of course there are penal provisions uske liye creditor agar creditor or any complaint from creditor. So in that case what I am citing was an application by the central government. So who can file, on whose instance such an order can be passed, it is defined under this section. Next, please. So now we come, these were all legal provisions. Now we come on the practical aspects of all these things. What triggers? It is this question can come to anybody's mind, practitioner, corporate, investor. So what triggers 3 I's? Why the government passes order for 3 I's? So I would say that the most common trigger is the complaint and analysis thereof. Why I say analysis? One cannot take a decision just on one stray complaint. In MCA 21, there is a repository of e-complaints where the data is capable of being analyzed. I had personally conducted, many analyses on this aspect. And even paper complaints are converted into e-complaints. All registrars have standing instructions to convert all paper complaints into e-complaints. So once the data is there in the system, it can be analyzed. Now let us take a case. There is a stray complaint against a company. I'm not saying it is not important. Even one complaint can throw a lot of material for the authorities to take a decision. But let us take a case where there is frequently, complaints are running every day. There are complaints. It mostly happens in case of chit fund companies or deposit related complaints. There are very notorious companies into that also. All of us know those names. So a decision can be taken on the basis of a complaint or number of complaints. And then when we analyze those complaints, we can understand the nature and the quantum and the seriousness of the matter. Then I would also say that there is now, like technology is there for the private sector to use. The technology is available for the governments and the enforcement agencies also. Gone are the days when every department was working within their own, objective or blink, if I have to say, departmental blinkers. But now there is an information convergence across government departments. There are well-established information sharing mechanisms within the government departments. And there are electronic interfaces also, right? Where information is shared by one department to another department. To quote an example, banks do share information, right? Income tax department shares information. So if we have to discuss just in terms of, say, Companies Act or LLP or IBC, so the sister departments are SEBI, income tax is common for all, RBI is there, right? Similarly, GST is there, IBBI is there. So like this. So I can say without sharing much on what mechanism do departments have, but all I can say is that yes, all of us should understand now that there is departments are even using AIs and information technology tools for information convergence. And now it will be very foolish or naive on the part of anybody to understand that any differences of information, gone are the days when people could file and one set of balance sheet with sales tax.
Yeah, one set of balance sheet for income tax and another set of balance ROC.
Those days are long gone. Then within MCA, we have early warning signals we had established. I can take the privilege of being part of all those exercises where we could
I know this,
get identified early warning signals, and systems do throw alerts. Then audit qualifications, adverse remarks is also a trigger.
Sir, one question here for complaint and analysis thereof for first point. Generally, in practical world for closely held companies, there is a lot of cases related to removal of directors. So in those cases, if some one aggrieved person has come to know they are going to be removed, and we have a provision under ROC, we can raise a complaint to ROC and to ask the ROC to don't attend any form related to that, means declare the company under the dispute. But this type of complaint, ROC is why not taking on serious basis?
No, look, the literature is very clear that there is definitely a difference between private disputes and public interest.
Sure.
Government is here to address public interest. Private disputes can be settled by the parties before the appropriate forum. You know, there is NCLT, there are courts where they can settle their private. We are not here, and ROC is not empowered to adjudicate. He cannot sit on judgment of private disputes. The law is
sir, it is not about to say take.
No. I'm coming to your specific questions of forms, right? Rule 11 of under chapter 24 is very clear. Rule 11(1) says that it is the duty of the company to file a correct form and attach all required attachments. And in particular, rule says you have to attach the proof of number of shareholders voting for and against the resolution. Right? And rule 2 says that if ROC finds that there is a violation of the act in this process, then he has to refer the matter to regional director. Then regional director will give an opportunity of being heard to both the parties and pass a speaking order. This is precisely with regard to removal of vacation of and removal of directors. There is a specific rule to that. There are divergence of practices, I know that. Certain ROCs are following this in one case. So without commenting on what practically is happening, but the rule, because I was involved in the rule-making process, I know the logic behind this rule. And then that route has to take place. ROC cannot adjudicate, ROC is only performing his ministerial act while dealing with forms, right? He is not sitting on judgment. Law is very clear. Very famous case of Delhi High Court is on S.K. Bhattacharya versus Union of India or something like that. In 1992, let us take a case. If a person is working as managing director, a proper resolution is passed. He is signing checks. He is doing everything what a managing director is supposed to do, as per the resolution passed. But the form for his appointment is not filed with ROC. Does it mean that he is not the managing director? No. Non-filing of a form is a ministerial function, is a separate requirement. It is a post-event form. Event has already taken place. Form can be filed with 30 days and with belated fee also. And there is a punishment for non-filing a form. So the Delhi High Court said, no, filing or non-filing a form, availability or non-availability of form with ROC will not decide this issue. The issue will be decided on the facts of the case and the resolution passed by the relevant body, the board or the shareholders, right? So it is a futile exercise, of filing a complaint, preempting something instead of filing a complaint with ROC, one should immediately rush to NCLT and seek interim prayers on, holding a meeting if he's agreed, and if he has a case, right? I have seen many cases, where, I have seen one such case without naming that case. And this I am saying on divergence of practices across ROCs, though I belong to, that is our fraternity, where the directors were employee directors, right? The holding company was, one company was holding all 100% shares of the subsidiary company, and all two directors were employee directors only. And EOGM was properly called, and by full majority, those two employee directors were removed. Those employee directors filed a complaint with ROC, and that form was not approved. What right do an employee director has, when the resolution is passed by the, so ultimately matter went to the court, and court decided it, this issue. But all I'm saying is that Rule 11 is very clear on this issue. There can be cases, I am saying, there can be cases of wrong filing of forms also. There can be cases of brute, misuse of, person can be wrongly removed also. There can be cases. And there are plenty of cases where a person is removed, right? Wrongly.
My point is here, the mechanism provided by the ROC, that is declare the company under dispute. Declare the company under dispute. Is for what? Why this mechanism?
There is an old circular, 1 of 2012, right?
Yes, sir. That is still continuing.
But that, my understanding is after Rule 11, that circular loses its, relevance, right? And after repeal of the old act also, now a repeal notification is also there, Anyway, Rule 11, which is a notified rule, is very clear, and it very clearly defines the duty of the ROC and also defines the duty of the regional director.
So in those cases, it is suggestible to our practitioner immediately move an interim application before the NCLT.
No, precisely. If he is
under Section 241,
if he is aggrieved by even calling of a meeting which is not regular, right? Or if he is aggrieved by his removal, he has to approach the court only, because ROC cannot adjudicate it. And if there are ministerial gaps, if there are gaps in the forms, then a complaint can also be filed with ROC, because form is wrongly filed. It is not containing, the required attachments. It is not containing the required
not served by notice,
percentage of persons voting in favor or against, right? So those issues can be raised. Ministerial issues can be raised. Okay. So audit qualifications. So recently, I was involved in that exercise also. CARO has been, very, very drastically amended. It was supposed to be implemented from financial year 2019-20, but it was extended by another year due to COVID. Now there is a lot of scope and lot of responsibility cast upon the auditor to give answers to those relevant questions in CARO and qualification. And then 143 subsection 12 is also a greatest and very significant trigger, where the law gives a responsibility to the auditor to report fraud in a sealed cover in the given circumstances to the Secretary MCA if he comes across any fraud by or against the company, right? Beyond a threshold, 1 crore hai uska. And the system in MCA is capable of identifying qualified reports and reports containing adverse remarks. Then we also have a SOP on we had developed those indicators of attributes of a shell company or shell activities. This is also a trigger. Then we have where applications are filed by RPs in the CIRP process, reporting preferential or fraudulent transactions after the transaction audit or forensic audit under 66 or 65 of IBC. Then another trigger is reporting of bank frauds or declaring persons as willful defaulters. Then again there is a very robust system of sharing that information by banks to MCA. Orders by tribunal courts, which we have already discussed. Special resolution passed by the companies we have discussed. Recommendations by state government or central government, there are cases. Scrutiny of documents filed with ROC. So one of the, there are many things that this depends on, it is a combination of, early warning signals which system is capable of identifying, and also the physical, examination of a document by through human intervention. One, I always say, too good or too bad performance, right? Irrational financial results, right? Jab sara sector is in losses, one particular company is in profit, or vice versa. So, or in disclosures, in financial statement, Schedule 3 disclosures, we find gaps. Or inputs or alerts from central process. We have a lot of, now within our ministry, we have central processing centers, we have CRC, CPC, CSC, and CPACE also. If we get those triggers or alerts from those centers, because they are specific centers to deal with certain specific things. So we have Central Scrutiny Center, which has been given the mandate to examine STP forms. And balance sheet is one such form, which comes to financial statement comes through STP process. And even CRC also throws many alerts from time to time. So these are normal triggers on the basis of which the central government or the registrars decide to conduct 3Is. Next, please. Now, why inspections? Inquiry is a, sort of a very preliminary thing. How do we differentiate whether it is a fit case for inspection or an investigation? So inspection normally is, it is a graduate, it's a process. So when in an inquiry, there is a refusal or disobedience so subsection 3 also empowers the ROC. Inquiry indicates need for deeper examination of books of account, like volume of records. Need to verify the disclosures in financial statements with books and records, collection of evidence, recording of statements, physical verification of the registered office. कई बार allegation होता है that the company is not being maintained, it is a shell company, it is not existing at the given address, and there are a higher number of complaints. Investigations are normally in those cases where similar but larger interest, public interest, or larger number of people are affected or stakeholders are affected. Inquiry indicates elements of fraud, specific issues to be examined. So if I compare inquiry, inspection, and investigation, let us compare it to what a doctor does. Inquiry is like a clinical examination. आप डॉक्टर के पास जाते हो, डॉक्टर कहता है ओके मेरे को आंख दिखाओ, नाक दिखाओ, कान दिखाओ, आपका फीवर, he just checks your fever, vitals, he just checks vitals, right? But if he feels that no, there is, you need an X-ray chest, right? Or some blood test is needed. So that can be equated to inspection, where you penetrate deeper, collect some further, before diagnosing a particular disease. He says, okay, let us have CBC kara lo, complete blood count kara lo, right? Or liver functioning test kara lo, right? So these are all specific. So this is an inspection. Investigation is a targeted surgery sort of, when clinical examination or certain other, tests, they give you a hypothesis that, okay, a tumor is there, but I don't know whether the tumor is a benign tumor or a malignant tumor. But tumor is there. Similarly, in investigation, some fraudulent, some activity, some financial transactions have taken place which are not normal. This is known. But is it actually fraudulent in nature? Or is it just another business transaction, which is an innovative business transaction, which is not just a routine business transaction, right? Or since large number of people are making hue and cry and saying that some fraud has happened, and there is a prima facie case that yes, it is there. Now let us rule out that hypothesis. It is a targeted surgery. Just for simple understanding of things, we can say that investigation can be can be compared to that exercise. Next, please. Now, this is also very important for the practitioners to know, particularly in cases of public interest. When an investigation is ordered under 210 or 212, what additional steps government takes or is empowered to take, basically to protect their public interest. So on one hand, we have ordered an investigation, and immediately, since there is a material already on record, or there is an opinion by the ROC or the registrar or by the inspector that there is a fleeing risk, banda bhag jayega country chhod ke, right? The magnitude of alleged public interest or alleged fraud is so that he can leave the country. Then the government has the power to issue a lookout circular, right? So, a request is raised to Immigration Bureau. From DIN records, his passport numbers and particulars are shared. Then that person is stopped from leaving the country. That is one such step. The second step is we file petitions under 241, 242, 246, read with 339, where interim prayers are for freezing of assets of the respondents. And we have done this in case of Satyam, we had done in case of IL&FS. We have filed petition under 241, 242 in Delhi Gymkhana case, but there was no freezing. We had not sought for freezing of assets. In Nirav Modi Gitanjali Gems case, we had filed petition under 241, 242, and also freezing of assets. And still, assets have been frozen, and the respondents have been allowed only to withdraw subsistence allowance or some monthly allowance out of their bank accounts, lockers, everything is frozen. And then we also can file application for recasting and reopening of financial statements under 130. 130 is on a different premise when there is a mismanagement and fraudulent activities. So the old financial statements can be recasted. We file an application, central government files an application. This law has been settled in case of IL&FS, where one Mr. Hari Shankaran had gone to the Supreme Court, and Supreme Court said that there is nothing wrong in this petition and in this power, and accounts can be reopened and recasted. That law is also settled. Then the other proactive step which we can take, the government can take and takes normally, is that to refer the matter and share the information with sectoral regulator or other concerned departments. Like in case of NBFC with RBI, in case of listed company with SEBI, in case companies there are issues with regard to RPs and CRP, then to IBBI, and so on.
So here one question about under section 130 about recasting and reopening of finances. This is on the basis of findings of the investigation, or this is on what basis this
can be on the basis of, in IL&FS case, it happened on the basis of on the prima facie case, not just on the basis of report came later. In IFIN case, report came later.
So So why, sir?
Yeah,
Why
there,
recasting this form?
there was already an enough material, right? You
Hmm.
know, the court has to be satisfied that there is an enough material, right? Which shows that the earlier balance sheets are not reliable. You know, let me for your convenience, and this is dealt in Harishankaran case by Supreme Court also, because that was the first ever case. I am the petitioner in that case. My
Acha,
affidavit is.
acha.
So I was in the Supreme Court also when.
That's why I want to know more
Yeah.
clarity on this
Yeah.
particular
You
section
know,
under section
in
130.
Harishankaran case, Supreme Court has dealt it very beautifully.
Sir,
Let me read out. Threshold is much lower in 130 than in other cases. It says, you know, and there are enough safeguards also, which Supreme Court has, you know, dealt in the order. A company shall not reopen its books of accounts and not recast its financial statements unless an application in this regard is made by the central government, the income tax department, the SEBI, any other statutory regulatory body or authority, or any person concerned, and an order is made by a court of competent jurisdiction or tribunal to effect that the relevant earlier accounts were prepared in a fraudulent manner, or the affairs of the company were mismanaged during the relevant period, casting a doubt on the reliability of financial statement. The Supreme Court said that it is enough if we meet these two thresholds, right? That the earlier accounts were prepared in a fraudulent manner, and the affairs of the company were mismanaged and casting a doubt on reliability. That's it. And this material to you can be, you know, it depends on case to case basis, can be, as you said, as a finding of an investigation or a finding of even an inquiry, or a material already in your possession, right? In Ireland, we had that material already in our possession, so we got an order, which was challenged first before NCLAT. That application, that appeal was also rejected, and Supreme Court finally settled this issue. In CG Power case, again, that material was with the company itself, because the company, now these things are got an investigation conducted by a law house, and 9 or 10 such transactions were came out of that investigation, which was enough to show that earlier accounts were not prepared in a fraudulent, and many of those transactions were not even reflected in the financial statements. So while the investigation with SFIO was still pending, the court passed an order for 130. And there is another aspect into this thing. There is another aspect into this thing, that when we first approached the NCLT to seek a permission to appoint a firm of chartered accountants to recast accounts, right? So at that stage, it is enough to make a prima facie case. It can so happen, and then another firm is appointed to audit those recasted accounts. No hypothesis. Still, there can be a case that recasted accounts, that firm can say, no, there is no need even to. So there is no material difference, right? So at that point of, for approval of recasted accounts, again, the applicant has to go to, or company has to go to the tribunal. So there are two checks, right? One is,
sir, you are saying that for preparation of financials we need one CA form, and for audit we need different CA form,
definitely,
or both person can.
no, there is a reason for that. जो आदमी खुद अकाउंट्स बनाएगा वो अपना खुद ऑडिट तो नहीं कर सकता ना.
मतलब ही नहीं बनता.
So the first
Sir,
form is only to recast. So he is basically just an accountant, right?
Okay.
not an auditor, right?
Hmm.
Okay.
Sir.
Next, please. So what type of non-compliances do we come across when we conduct? So broadly, there are 2 or 3 categories. One are, of course, secretarial. Statutory register books et cetera are not maintained, or completely are not maintained at all. Filing of statutory documents with ROC, MCA, secretarial compliances, right? Or accounts related compliances of formal, form and content, what we call it, right? Accounting, follow of accounting and auditing standards, audit, cost audit, corporate governance norms, and certifications. Or if I say it in other words, so violations are into 3 parts, as we discussed earlier also. 1 are punishable with penalty, 2 compoundable, 3 non-compoundable, right? Including fraud. And then the highest level of, which can be irregularity can be found is a fraud. That's it. Next, please. Are we running out of time?
No, sir. We have still time.
Okay. So non-compliance is violation default. So these are indicators. I'm touching upon those indicators. So delay, default or delay in filing of due documents, not maintaining registered office, non-maintenance or incomplete secretarial record, not holding, delayed holding of meetings, filing of documents with incomplete information, non-compliance of accounting standard, financial statement not prepared on the prepared form, incomplete or no prescribed disclosures given, shifting of registered office without intimation, abnormal related party transactions. This is next, please. Role of auditor, is very important. We have seen recently many cases, or a few cases, not many. I don't want to sensitize, create a sensation out of it. But there are few cases. Normally, I believe that auditors do, conduct their affairs with responsibility. Most of them largely are working with a lot of care and accountability. But there are certain instances where there are instances to accept responsibility for fraud detection. If the auditors are not watchdogs, then who is? So they become greedy per year. So easier to sell lucrative consulting services from inside. That is why we have Section 144. The few auditors got too close to clients. So that is why we have rotation of auditors, right? So with 1 or 2 instances, entire community of auditors is seen with awe and suspicion due to malpractices of a few. Next, please.
Sir, here one point is about auditor. Auditor is generally pointing that in their report, it is opinion. So that opinion is conclusive thing or just sake of this is the opinion only?
Our secretarial standard, auditing standards are very on this issue, right? How to form an opinion, whether you are giving a disclaimer or a qualification or emphasis of matter, is all defined and documented in auditing standards, right? In the old act, under the Companies Act, qua the institute and the auditor, the compliance of auditing standards was mandatory. But there was no concept of auditing standards under the Companies Act. Now under 132, we have made it mandatory. Now there is NAFRA also for certain set of companies. So that literature, we can speak on hours on that subject. This is very vast subject. But if you are trying to say that auditor takes a defense that it is just my opinion and there is no legal sanctity to it, that innocent statement is not correct, right? So auditor has to give his opinion. He has to decide on you know, in the light of auditing standards, whether he has to give a disclaimer or a emphasis on met or a qualification. And of course, in all this, there is a concept of materiality, right? So if the issues are so material that they affect the truth and fairness of the financial statements, that is quite a serious issue. He qualifies when he's certain. He qualifies. In the literature of the institute and auditing standard, disclaimer is even worse than qualification.
Sir.
When he says that I was not given adequate information, right? So I cannot quantify, right? So that standards of auditing issued by institute are quite robust, and now you must have seen. I'll be discussing, if time permits, the case of Deloitte Haskins also.
Yes, sir. We have 5:15 our closing time. So
I'm a petitioner in that case also. It's my affidavit is there in the court.
Sir.
So that is the first ever case where finally Supreme Court has said that Section 140 subsection 5 is constitutional.
Okay.
And even if you can't run away, even if an auditor resigns or his tenure expires or resigns during the course of inquiry, or so, still Section 40 subsection 5 is applicable. He can be changed. He can be disqualified from being appointed auditor of any other company. So that matter is still pending in NCLT. But in principle, you know, the Supreme Court has passed an order in that aspect. So applicability of Section 140 subsection 5 has been clarified. And NAFRA has recently passed many orders, you know, penalizing auditors and even debarring a few of them. So the role of auditor is very, very important, very important. And he is actually, I personally understand, is actually a very vital bridge between the stakeholder and the company, right? Because he is the first, you know, person who actually goes through the record. Government cannot go and conduct investigation into affairs of every company, right? These are the checks and balances within the system, where company secretaries, when they give secretarial, you know, they conduct secretarial audit, or auditors when they, you know, give their report on financial, after conducting financial audit. So all these checks and balances and roll up, and cost auditors, of course, in cases where cost audit and cost accounts are applicable. So all these three professionals are very important in maintaining that balance in the whole ecosystem. Anyway, so when we, you know, sum it up, so any 3I, all said and done, is a fact-finding exercise. So the IO or the registrar has to find answers, what has happened or not happened, meaning thereby, what are the acts of omission and commission? How? Basically to spell out the modus operandi, right? When? Basically the period of default. And it also decides the limitation issues. Today in 2023, you know, if my registrar throws out a violation happened in 2015, right? So, of course, in case if the law of limitation is applicable in that case, so timing and period of default is very who. So basically, who is the officer in default? किसने किया है ये काम? Who has done it? Why? What is the motive or mens rea? Where decides the jurisdiction? Whether it has happened in India or abroad, whether it has happened at registered office or a branch office, right? So no prosecution can sustain without true and clear answers to these questions. And the job of the practitioner is to find gaps into that, right? So if the report is not clear on all these 5-6 questions, definitely practitioner will be very happy to find those gaps and say that this report cannot be relied upon and nothing survives it. Next.
Sir, this topic is so vast and so uh, wide. It is very difficult to cover in this 1.5 hour. So, sir, now it's time for some questions and answers. And if anything specific remain from your side, you can take 5 minutes more. And then after we can start our question answer session.
No, I'm open to it. We have covered 3 eyes, right? My next part of though you had not specified that I had to cover fraud also, but of my own I thought that this subject will not be complete unless we touch upon
Sir, please, sir. Fraud part you start, sir.
But that will take some time, right?
Sir, we have 10 minutes, sir.
Okay. Next, please. Very quickly we'll cover.
Sir.
Desired outcomes of 3 eyes. अब करनी है तो क्यों करी है हमने? Why we have done it? There is always, no exercise is without any objective, right? What outcome can be there? So we'll verify facts on the basis of investor complaints or otherwise. Redress grievances. That is a very low level thing, right? Strengthen information in registry. Any information additional information which comes in the corporate registry is part of the registry and is open to public inspection. So to that way, corporate registry gets strengthened. Financial statement document indicate prima facie non-compliances or variances, then those are brought to logical conclusions. IPO, FPO, end use is also an objective, and there are standing instructions. Address public grievances by filing report with NCLT in case of public interest 241, 242. I have already referred to ILFS and few other cases. Winding up, this is one important case where I have personally, this again is a case, very important case where I had personally fought it out. Which is also, this can be this is a landmark judgment which has been, this also has been, finally approved by the Supreme Court, is Devas Multimedia and Antrix Corporation and others. Yes, Union of India was also a party, where a petition was filed before the NCLT alleging fraud 271 subsection C, where company can be wound up on the, this company had committed a fraud with ISRO and Antrix. And finally, so this can winding up the company altogether. And it can happen in case of shell companies also, which can be a very logical conclusion and desired outcome of in 3I. Interim measures to protect, which we have already discussed. Action against auditors, 140 subsection 5. Deloitte Haskins case, I have already discussed. Action against certifying professionals in case forms have been certified in a fraudulent manner, then 448, 449 comes into picture. Then penal action to bring the culprit to book. Then disgorgement under 224 subsection 5. This petition can be filed with the NCLT. The crime money can be disgorged, and it goes to either to the Consolidated Fund of India, or victims can be compensated. Next, please. This logical conclusions we have already discussed. Next. Next. Non-compliances versus fraud. So, all said and done, non-compliance can be a very innocent mistake without any intention to commit any fraud or harm. So that is why there are provisions for civil penalty, decriminalization. That is why there are compoundable offenses, right? On the contrary, fraud is an array of irregularities, illegal acts, intentional deception. And non-compliance can also indicate a potential fraud. If it is corroborated by array of events with mens rea or guilty mind. This also depends on the facts of each case. Next, please. So fraud इसको छोड़ दीजिए, हम सीधा कंपनीज एक्ट की डेफिनेशन पे आ जाते हैं. This is so Companies Act, it says 447 now is defined. Fraud is defined under explanation to 447, which includes, mind it is an inclusive definition. It is not an exhaustive definition. Includes act of omission, concealment of any fact, or abuse of position committed by any person or other person with connivance, with intent to deceive, to gain undue advantage from or injure the interest of the company or shareholder, a creditor, any other person, whether or not there is any wrongful gain or wrongful. So attempt to murder is also funny. Attempt to commit fraud is also funny. So now we have a definition under 447 for fraud. And there can be many gray areas, many financial, basically, except for some technical violations of delays in filing forms, etc. Everything in fraud settles down to fund flow. पैसे की बात है ना ultimately. पैसा कहाँ से आया, कहाँ चला गया, from where the money has come, and directors are in fiduciary capacity, and then they have contractual obligations also. Fiduciary capacity, the law is very, we know, all of us know what is the position of a director. They are holding company or running company in trust for the stakeholders, now real owners. And contractual obligation includes, like in deposit cases, you are bound by a contract to repay it, on maturity. Bank defaults. So by raising loans, you are bound by a contract to repay that loan on demand or on expiry of the period, or to use it for the purpose it was taken. Similarly, in IPOs, you have declared something in your prospectus. There are certain objectives of the IPO. So that too is a sort of contractual, obligation towards your shareholders, on the basis of which you have raised that money. So end use of that IPO proceeds is also. So there are statutory duties and there are contractual duties also. If you fail into those duties, then fraud can be alleged. And then ultimately taking a benefit. If you are beneficiary out of it, then things become more serious. Next, please. Now, one important distinction I would like to make is there are two types of fraud. One is by the company, another is against the company. Right? So by the company, the biggest example is having a shell company, right? To cheat the public, the very existence of the company is created to launder money or to cheat public. Company is maintained for that purpose. In that case, the corporation or the company is the victimizer, and the benefits are financial or otherwise, and they are subject to civil or criminal liabilities. Against the corporation, there the company is a victim, and there are financial, legal, and reputational risks involved, and potential civil recovery or corporation. So the law covers both types of frauds. The other, against the company, normally are frauds by employees, pilfering, or embezzlements by senior management or middle management or whatever. So as government is more concerned with frauds by a company, because that is where the public interest is involved. Generally, it is thought and understood that companies are capable of, protecting their own interests in case of fraud against the company. But the line is very thin. That is why the law gives a responsibility to auditor under 143(12) to report both type of frauds. Fraud by a company or fraud against it. Next, please. So this is the whole, kaun karega, management, board, relationship with others. This is the whole, matrix of things. Organization, industry, financial, ye to chhod do, aage chalo. Anyway, so then there are 10-15 more slides. This will become more very technical and
Sir.
very important. I know that we are running out of time. Now we can take questions, and some other time we can have a separate session on.
Yes, sir. Certainly, sir. Certainly, actually, your knowledge power, your knowledge bank is so much and so much things. It is not covered in 1.5 hours, and we need much more time than we have today. Sir, one question asked by person: can SFIO ask for document details of transaction from another company with respect to transaction with a company which is being investigated by SFIO without even mentioning the period for which details are required?
No, your voice is you are mute. Voice बंद हो गया आपका.
No,
I could hear
now it
half
is
of it.
audible.
No,
Sir,
you.
again, I'm starting, sir. Can SFIO ask for documents, details of
Okay,
transaction?
I got the sense of the question.
Uh,
The first part of the question is the answer is yes, they can call. The law empowers the IU to call for information. The second is not without specifying the period. That is not correct to my mind. You know, again, the point remains that the recipient of the notice cannot reply in thin air. You know,
obvious.
he has to be given, at least the basic information, basic, query, the period to which it belongs. आज into 2023, if someone asks, a transaction which has taken place in 2010, right? And a transaction which is, there is a hell of a difference between, after all, I'm required to maintain my accounts only for 8 years, right? So, second part, I do not agree. To my mind, yes, it is the duty of the IO to specify the period. There are other issues also, I can sense the question. So people are not even asked whether you are being called as an accused or as a witness, right? I should
Absolutely,
know
sir.
if I should know whether I'm so these are certain gray areas. We all know that. But yes, the common, I would say personally that the common rule of fairness and transparency
It should be,
should be there in conducting investigations.
sir. Another question is a company cannot change its name in case inspection is carried out. First part. Second,
Again, your voice.
sir, just Nick at speaking. And it is pending against such company. In case inspection result is no prosecution as no further notice or no communication received from MCA, how the company is informed that inspection is closed against him
Look,
in
there is a
case of
column
change of name?
to the best of my information. There is a column. I have seen a few cases also. There is a column in the form where a question is asked from the applicant whether any inquiry, inspection, investigation is pending against you.
Yes.
He actually writes that yes, some inspection was conducted. I had received the notice. I had replied. Thereafter, I have not heard anything. Right.
Hmm.
Now, the job of the company is to this extent only. It is for the adjudicating authority to verify this fact. Whether that, because that rule to my mind has been amended, or it was initially also there, that nothing stops if it has been concluded, right? Now it is for the adjudicating authority to verify whether the inspection which was initiated has been brought to logical conclusions. Right? If it has been brought to logical conclusions and nothing survives in that, then of course approval can be granted.
Sir. Sir, with this thing, now question is over from other questions is also there, but same, you had already responded for those questions and those points. With this thing, sir, once again, I'm giving a very thanks to you and for your information, sir. Right now, we have approx 6,000 participant to attend this program webinar.
Right.
And really to thankful to all the participants who are very patient listening, and hope those participants have gained lot about this particular things, because in coming time all company secretaries are going to be a very relevant for this particular things, section 206 to 2229. So this is a very crucial area for we company secretary, and sir is always available to give their valuable things to us. And in coming times, we are going to arrange further more session on this specific aspect, which today we have left, because again fraud and related matters are very crucial for this inspection, inquiry, and investigation. So, furthermore, we are hopeful for further more things in coming times. And sir, once again, our ICI is very thankful for your valuable time, and we our participants are really benefited a lot. We are receiving lot of appreciation on my WhatsApp number, and lot of points people are raising, which you have already deliberated and given to all the members. So once again, thank you, sir. Thank you for your valuable time.
Thank you, ji. Thank you very much. Thank you to the institute and to you and to all your team. And the efforts by the institute are really commendable. Thank you very much. Thank you.
Thanks, sir. Thanks.